February 2025 call of the docket for the Court of Criminal Appeals for the Eastern Section. We're happy to be here this morning in Knoxville. It's a beautiful day, so we're expecting some beautiful arguments and some beautiful cases. And you'll get some beautiful opinions at the end of it. So, I'd like to introduce our panel this morning that will be serving with me. My name is Tim Easter. I'm from Williamson County, out of the middle section of the state. To my right and your left is Judge Matthew Wilson from Madison County, the Eastern Section. Judge Wilson has been on the court since 2023. And then to my left this morning, we're pleased to have Judge Mark Ward with us. Judge Ward was a trial judge over in the 30th Judicial District for 18 years, about 18 years, and then was for the last year and a half has been a senior judge serving all across the state. So we're very glad to have Judge Ward, and we thank you for agreeing to sit with us this morning. Unless you have previously requested additional time, each side, as you are aware, will have 20 minutes per side. If you'd like to reserve some time for rebuttal, if you're the appellant, please let us know when you come to the podium. And we do use the light system here, which will indicate when you have, I believe it goes yellow, when you have 1 minute left, and then red means you're done. So we're glad to have that system. Madam Clerk, are there any announcements before we begin? Okay. Call the first case.
State of Tennessee versus Harlan, Ferguson.
Good morning, Mr. Harwell. We are, aware that you have asked for some additional time. Both parties asked for additional time, so I believe you have 25 minutes total this morning. Is that correct?
Yes, and if I could reserve 5 of that for my rebuttal.
Yes, sir. Thank you.
May it please the court, my name is Jonathan Harwell. I'm here on behalf of the defendant appellant Harlan Ferguson. As the court is aware, I have raised a large number of issues in my brief. I don't wish to deprecate any of those, but I do want to focus on 2 evidentiary issues relating to the blood and the medical records, and then focus on the post-trial issues with the rest of my time. To start, I want to focus on the blood, the chain of custody relating to the blood that was analyzed and used as evidence of intoxication of Mr. Ferguson. Just to remind the court of the facts relating to the blood, this was a crash on February 4th. Mr. Ferguson was taken by ambulance to the hospital. There was a search warrant that resulted in a blood draw from Mr. Ferguson. That is not at issue on appeal. There was also a search warrant that resulted in officers going to the hospital to obtain blood that they believed had been taken by the hospital from Mr. Ferguson's body. So that is the blood that we're arguing about. That happened the day after the crash. 2 officers, Mr. Amburn and a forensic officer, went to the hospital armed with a search warrant, obtained from a hospital technician 4 vials of blood that had a misspelled label saying Harlan Ferguson and a time on them. Those vials were then taken to Sheriff's Department evidence refrigerator. There was evidence that anyone in the forensic department could have had access to it, but that would have been logged. It apparently stayed there for some 15 days before arriving, having been taken by a fingerprint technician, according to the logs, arriving at the TBI. There was then a very good chain of custody as to what happened to the blood after it arrived at the TBI. In our brief, I've sort of set out 2 sides of, or 2 weak parts of the chain of custody. As I said, there was not this languished for 15 days in the evidence locker. Was not a lot of evidence about procedures for how that was maintained. There was not testimony from the individual who took it to TBI. There was not testimony as to who specifically would have had access to it in that time period. So if that's all we had, I think I would probably still be here making a variant of the same argument. I know that is the kind of argument that this court has seen a number of times, and there's opinions sort of pointing both ways. When you have blood samples staying in police department or sheriff's department custody for a long period of time and sort of not a great deal of information about the circumstances in which it is kept. What makes this case dramatically different from those cases and really sets it aside is not that part of the chain, which I think is weak, but the part of the chain leading up to that point, which is weak or even non-existent. As I said, there was testimony by Mr. Amburn saying he went with a forensic officer and a search warrant and obtained 4 vials of blood from the hospital with the misspelled defendant's name on them. What there was not was any testimony from anyone at the hospital or even with specific knowledge of what happened at the hospital. That is, there was no testimony by whoever took blood, if indeed blood was taken from Mr. Ferguson. There was no evidence as to what was done with that blood. There was no evidence how that blood was stored over that time period between the crash and the search warrant being executed. There's no evidence as to how the laboratory technician decided which blood vials to hand to the sheriff's department. There was a just complete absence of information other than just by supposition or conjecture as to how the blood was taken, how it was treated, and what happened to it. So it was made, I apologize perhaps for setting forth this verbatim at such length in my brief, but it was made clear at trial, the cross-examination of the forensic officer, where defense counsel asked her again and again, do you know this about the blood, that about the blood, this about the blood? And she said, no, 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 ultimately saying, sheep, this is the best forensic person in terms of the blood that the state offered. She ultimately said she couldn't vouch for the integrity of the blood.
And she's the TBI agent that tested? Am I following you on that?
No, the forensic technician at the sheriff's department who went along with Mr. Amburn to collect it, and she was the one who then took it to the evidence refrigerator. So she was forensics for the sheriff's department, but she agreed, couldn't say anything about what happened to it before she took it from the hospital. I do want to emphasize that I think it matters. This was not a sort of surprise or a gotcha situation where there was just a thing fell through the cracks at the trial. This was raised in advance of trial. The defense was saying, you can't prove that was our client's blood, you can't prove nothing suspicious or inappropriate happened to it. It was litigated at a hearing prior to trial. So this is not sort of second guessing where we have identified that maybe they missed a witness. This was identified in advance. The claim was made in advance. You don't have anybody from the hospital to say this is actually our client's blood. It was actually taken from his body, and it was actually not confused, tampered, diluted, messed up by the testing in any way. The state was fully on notice of that and made no effort even at trial to fix that problem. I note that the state has not identified any case, I think, that is similar in this situation. I've cited a case. I didn't actually explore the facts as much as I could, but I think it's worth the court considering. That's the Cannon case that does set out the governing law. What's interesting about the Cannon case is it's also a hospital case. It's different in the sense it was pantyhose that were seized from a hospital purportedly from a rape victim taken apparently from her hospital room. There was a very good chain of custody for the pantyhose once it was collected from the hospital through testing by an outside agency. DNA determined a link with the defendant. But what the Supreme Court said in that case was, actually, there's no connection between the pantyhose and the victim, because there was no testimony that these were taken off of her. There was no testimony that she said they were hers. There was nothing before the item was seized from the hospital. No information about that. That's exactly the claim we're making here, is this blood, if it indeed is from the defendant, if it indeed was taken properly from him, if it indeed was stored in a way that didn't contaminate it, if it indeed was not confused with any other blood samples, the state was required to present something about that time frame. It did not do so.
Counselor, did I read your brief correct that there was other evidence of the intoxication by virtue of blood? Was there a .135 test that was done when he first came into the hospital?
So there is, in the medical records, there is a sheet from the hospital that seems to indicate that at some point BAC of 135.
Well, was that admitted into evidence?
That sheet was admitted into evidence, yes.
And was there any objection to that testimony or that record? I mean, do we have a separate test, .135, taken immediately by the hospital when he first arrives? Do we also have that in this record?
That is in the record. Whether it's I mean, what's confusing is the state seems to suggest that's from the same blood draw. We don't know, was there two blood draws? Why would you have 135 and 180 at separate times? That does segue to the second, my second claim, I think, talking about the medical records, and that it's our position the medical record shouldn't be.
Wait a second before you move to the second one. If there's a .135 that's been admitted, why isn't your claim that your other evidence is harmless?
I think that the .135 really just raises questions. It is literally a notation, a handwritten notation on a medical record. Whether that was, we know nothing about the quality of the testing. We know nothing about anything about that other than it was apparently .135. So when you think about the kind of evidence that the state tries to prove intoxication with, is putting a TBI person on, talking exactly how they do the test, how they've calibrated the materials, the testing, all of that sort of information so that the jury knows how to give that weight. Here we just have a handwritten notation with a number that's vastly different from the other number that the state apparently came up with.
But wouldn't it be up to the jury to resolve the conflicts in those two numbers? But either way, your client's intoxicated.
I think the fact the numbers aren't the same suggests very much that there could have been some confusion or a problem in the blood samples. And that goes back to why we need a valid chain of custody.
Testimony in the record that would be this discrepancy is not explainable by any way except that it's two different people's blood?
No. There was really no discussion of the 135 other than it was read into the record by the prosecutor once the medical records came into.
Well, we all know the natural dissipation of alcohol in the bloodstream goes up and goes down, varying how long it is after it's consumed. And so, but there's no testimony in this record that talks about that.
That's right.
You just have 1.35, and what was the other number?
180.
Okay, all right.
I mean, the problem is the state's, there was so little evidence about what happened in the hospital. On appeal, the state is saying, in essence, there was one blood draw as soon as he arrived, and that's the one that must have been taken by the sheriff's department, and that's the one that was also apparently tested by the hospital. We don't know really any of that, but the state's assertion as to that doesn't make sense even on its face because it has different numbers.
But back to my harmless error analysis, I'm assuming if we were to find that that was error, that we'd have to determine whether it made a difference in the outcome of the case. Wouldn't we also have to figure into that equation that your client confessed that he was drinking and it took him until a certain amount of time to sober up, and that please apologize to the people I was running from. I mean, you haven't really addressed why this is not harmless error.
Yes, so I will say that in my review of the brief of the state on the blood draw, they've not made a harmless error argument. So I think that issue may be waived. To the extent that the court wishes to address that, I think, and I'll get to this, this is a reasonable doubt case. Yes, there was a purported confession, but there was a problem with the confession in the sense that the defendant had been given significant drugs before making those statements. There was some testimony that he was
not chosen to orally argue that point here today, and so are you conceding that the confession's admissible?
I'm not conceding the confession is admissible, but I think even if it is admissible, the jury could have discounted it, not sort of for a legal reason, but for a factual reason, right? We have a man who is in pain and under medication. We have an officer who supposedly witnesses this confession but makes no contemporaneous notes. We have another officer who supposedly witnesses the confession and is not even brought in as a witness. We have a statement as part of that confession. Mr. Ferguson says, it wasn't even until a certain period of time I was able to figure out what happened. The defense was made at trial. Even if he is confessing, he may not, A, be saying, I did this personally versus we did this, and B, he may not even know at that point, right? Having been through this experience, this trauma, and with this medication, he may wrongly believe that he was at fault.
You also had the two female relatives of his in the room, right?
They were asked to leave by the officer, I believe.
Okay.
So they would not have heard this. I think I'm actually going to skip my medical records argument because I don't want to have the court miss the importance of what happened after trial. The defense in this case was, as much as any case I've ever seen, the defense was to point the finger at the officers. Opening statement, we are here because of the choices of these officers, Mr. Amber and Mr. Henderson. The idea is Mr. Henderson wrongly engaged, or at least there's a reasonable doubt, he wrongly engaged in an improper pursuit in an unmarked police vehicle, that the car was fleeing from him, reasonably so, given the circumstances, that there was this crash, that because of the involvement of the two officers, they agreed they should not be, because they were witnesses, they couldn't also be the investigators. Yet for reasons that are still, I have never seen an explanation by them of, since they were witnesses, they couldn't be investigators, but they also were the ones obtaining the search warrant, interrogating the defendant. Mr. Henderson is the one who made the unilateral decision to release the vehicle without doing the proper paperwork, without consulting with law enforcement. So we have the defense at trial was this had a bad inception from Mr. Henderson. Mr. Amburn got caught up in that at some point. They then control the investigation. Maybe they're not trying to frame Mr. Ferguson, but they don't want, particularly Mr. Henderson doesn't want there to be a full investigation, and so they just control the investigation.
Why do you say there was a bad inception? I'm not sure I follow you on that.
Policy says that Mr. Henderson should not have been engaged in a high-speed pursuit in an unmarked vehicle. He had a big truck that was not, it was supposed to be an undercover vehicle. He starts chasing someone. He denies it, but the circumstantial evidence suggests he is chasing someone when he should not be, and they are fleeing from quite possibly not what they realize of law enforcement.
Is that a recognized defense to the crimes that your client was charged with? I mean, is that really a defense?
So it could certainly play into the idea of proximate cause.
So what defense would that be?
That the Well, let me, it could play into, is the proximate cause of this accident the intoxication, or is it the improper high-speed pursuit? But more importantly, this was a reasonable doubt defense, right? Reasonable doubt as to who was the driver, reasonable doubt as to whether Mr. Henderson was intoxicated, reasonable doubt as to proximate cause. The defense was perhaps there could have been answers to those. But we don't have those answers because there was never a proper investigation. And there was never a proper investigation according to procedure that would have answered all of these questions, because these two people, even though they're not supposed to be the investigators, they controlled the investigation.
Is that policy also, that they can't be the investigators?
That's what they said was the policy.
Because they were witnesses.
Because they were involved and witnesses. Also, they're narcotics investigators, right? Why they would be investigating a vehicular homicide anyway is another question. So we have the defense of reasonable doubt that is pointing to these officers that they have done something wrong. They have then restricted the investigation. Because the investigation is restricted, we don't have answers that we otherwise might have, and those are the reasonable doubts. After trial, we learned two things. We learned about Mr. Amburn that he has a verbal reprimand, bad in and of itself, but bad for a particular reason. He had a verbal reprimand for being aware of misconduct by a higher-up officer and deciding he was going to keep his mouth shut because it was to his own professional, possibly to his professional disadvantage to speak up.
Did that have anything to do with Harlan Ferguson?
No. So I believe that would have connected exactly with the idea of what Mr. Amburn did wrong in this case. So maybe the answer is yes. The idea that what he did wrong in this case was he saw wrongdoing by a superior officer and he played along rather than stopping it, speaking up, doing something different. And then even more significantly, we learn that Mr. Henderson, not the sort of paragon of professional values that the jury may have thought he was, he's a criminal, right? He is operating a criminal conspiracy out of the sheriff's department. And we learn that the way he operates the criminal conspiracy is not by doing things himself, but by by controlling his subordinates, by using people below him to make the illegal purchases, to do the improper construction. There is a text message in the indictment that I think speaks exactly to this, and that one of the members of his department says, "This is how it works in this division. You keep your mouth shut when needed, and when the chief needs something, we do it." And again, this ties directly to the trial defense, that Mr. Henderson, A, may have done something wrong, and B, has the power to pull the strings to keep things from coming out by having people below him essentially follow his will or predict his will. The court's generous. I've used its generosity, but I do want to say, as I said, I've never seen a case where the defense was so much, these officers messed up. These officers, this case exists because of their bad faith and misconduct. The state sort of made light of that. So this is a conspiracy theory. You don't have anything. And the truth is, they didn't really have much. They had a little bit. But after trial, we find this dynamite evidence. If you ever wanted to have a defense of this kind, this is like what you would imagine. This is what I would want. I would want Mr. Amburn keeping quiet when his superior is doing something wrong. And I would want David Henderson being a crook and running a criminal enterprise using his subordinates. Had that come out at trial under the very very low Nunley standard of may have resulted in a different outcome, this would have been a bombshell that absolutely would have affected the verdict. And I'll reserve the little bit I have left for my rebuttal.
We took up some of your time. We'll give you 4 minutes for your rebuttal. General?
May it please the court, Catherine Redding on behalf of the state. The trial court acted within its discretion when it admitted the blood analysis because the state reasonably established the integrity and identity of the blood evidence. The evidence entered into the record at trial showed that the defendant arrived at the UT Medical Center on February 3rd, 2016 at 8:32 p.m. The medical records also showed that a resident in the emergency department evaluated the defendant and created a treatment plan which included type and screen for possible transfusion. At 8:38 p.m., hospital personnel, according to the medical records, collected the defendant's blood, and a Dr. Christy Lawson, issued a type and screen order. The hospital, again in the record, typed and screened the defendant's blood in preparation for surgery, noting that he had a BAC of 135.
So these are all the medical records
Yes.
that you're talking about?
Yes.
Okay.
The following day, Captain Amburn obtained a search warrant for which authorized him to recover the defendant's blood from UT Medical Center. He went to the hospital lab accompanied by the forensic technician, Officer Bowles, provided the technician at the hospital with a copy of this warrant, which demanded specifically the defendant's blood, and he received 4 vials of blood that were labeled with the defendant's name. I think counsel is correct, it was slightly misspelled, but it's Harlan Ferguson's a fairly distinctive name, and you can make the connection very quickly.
So this isn't a case then where officers observe the blood being drawn?
No.
Okay.
To my knowledge, there were no officers at the hospital when Mr. Ferguson arrived. He was transported by ambulance. The paramedics took him in, but certainly Captain Amburn was not present. So it is distinguishable from, most of the cases that deal with chain of custody are talking about officers observing at the hospital, but this is different. There was no observation.
So is it the state's position that this sample that was obtained through the search warrant, part of that sample that was drawn by the doctors the night before or the day before? Do we know?
Yes, it's the state's position that we have medical records that establish that blood was drawn, that it was done for typing. If you can see the lab report, the results, and it shows clearly why the hospital obtained the blood, what they tested it for, and then as far as we can tell, the samples were at the laboratory, which makes sense given that we have lab results. And the officer arrived at the hospital with a warrant demanding the defendant's blood, received 4 vials that are labeled with the defendant's name, that have the date that match the intake form information, matching date, matching time.
But this, at the end of the day, this case, that was a question for the trial judge on whether or not that would be admitted.
Yes.
The trial judge allowed it. And then it becomes a question of weight for the jury to determine what that evidence, what weight it holds.
Yes, and the jury heard very clearly from the officers, from Officer Bowles, I believe I'm pronouncing that correctly, and Captain Amburn, that they didn't know, they weren't present when the blood was drawn, they didn't know how it was stored at the hospital. So the jury had that information. The jury also had testimony from the TBI agents who said that they would, when they get the samples, if there's anything unusual about them, it's noted in the file. We have 2 agents who said they didn't notice anything unusual about the blood sample. We have 1 specifically testifying that the blood looked to be in good condition and it was not degraded. And we also have Agent Massengill who testified that about the refrigeration. So maybe it wasn't refrigerated at the hospital, but it would take several weeks or months. And the defendant is pointed out, 3 weeks passed before it was tested at the TBI. But we have this information from the agents who did look at it and say it's not degraded. There's also some testimony in the record that talks about, well, if you had taken the cap off of the blood, perhaps the alcohol would have escaped, and it would take a long time for bacteria to get in and ferment and create more alcohol. So I think the jury had all of this information in front of it. It heard where the blood came from. It heard that the samples that the sheriff's office obtained had the name matched, the date matched, the time matched, and that was clearly stored at the sheriff's office. And I'd point this court to the Singh opinion from last year, which is published, in terms of for guidance on what kind of testimony is necessary about storage procedures at the sheriff's office. I think that was not a Knox County case. I think it was actually a Shelby County case. But the information that Officer Bowles provided about taking the samples back to the sheriff's office, taking them to the forensic laboratory, putting them in the refrigerator, who has access. She didn't provide a full list of every forensic officer, but she explained there are procedures in place. This is in a refrigerator that's only accessible by members of the forensic lab. When things are taken out, there is a log. So this information is enough to reasonably establish the integrity and identity of the blood evidence.
And he was indicted, I guess this gets to some of Judge Ward's questions earlier. He was indicted for per se DUI. So whether they went with the 1.3, 0.13, or 0.18, either way, it was per se DUI.
He was also indicted on DUI by impairment. So I didn't make a harmless error argument in my brief. I'll admit that that's correct. But I think that one can be made here. And based on, we have I believe it's Benjamin Sumner's testimony that about the afternoon before the incident, about Mr. Ferguson being at his residence drinking whiskey, drinking a large amount of whiskey, I believe is what he said. We have the defendant's own statements that he had been drinking. As you pointed out, he made a statement about how long it took him to sober up and realize what had happened. And we do have the hospital's finding of 135. And admittedly, that was not what the state was relying on, so there really isn't that much information in the record. But
Well, I'm just curious, was there any objection to that coming into the evidence?
I don't recall there being an objection to that particular piece. And obviously there was nobody from the hospital to testify about what that meant, but they did ask the medical examiner, who is a doctor, to kind of explain what that meant. So there was, and I don't believe there was any objection to that testimony either. But I just point out, I believe it's been a little while since I looked at Cannon with the Stockings case, but I believe that this case is distinguishable. If my recollection of Cannon is correct, the Stockings were in the hospital room that the victim was in, but there wasn't much to connect the victim to the Stockings. But here we have blood vials that are labeled with the defendant's name, with the date of the offense, with the time that they're drawn, and we have medical records that establish that those match, those times and dates and names, they correspond. We know that the hospital, from its own records, drew blood, and then we have samples. When the officer shows up at the hospital and says, I need the defendant's blood, this is what you're required to give me, these are the samples that show up. And the fact that the hospital's BAC was 135 and the TBI, which specializes in testing blood for alcohol, this is their specialty. The fact that there's a discrepancy there, I don't think goes to its admissibility. I think it would go to weight. Certainly it would be a different scenario if the hospital had found no alcohol and then it gets to the TBI and all of a sudden there's a lot of alcohol. And I'd also point out that this case is easily distinguishable from Gibson. The defendant has relied on that as to the 15-day delay in sending the blood samples to the TBI for testing. Gibson is a case where the officer handed blood vials to somebody at the forensic lab and had no idea what happened to it afterwards. There is just a dearth of information. But here we have clear testimony that Officer Bowles got the samples from the hospital, that she took them to the forensic lab. So there's the facts and circumstances of this particular case make it distinguishable, I think, both from Cannon and from Gibson.
I don't want your time to get away from you without addressing the issues that he's raised about these two officers.
Yes. I'd like to talk about the Brady issue first. It's the state's position the defendant's not entitled to relief because he was not entitled to Captain Amburn's personnel file. He could have requested the court conduct an in-camera review, but didn't do that. But more importantly, he's failed to establish that the evidence of the verbal reprimand was material. And had the evidence of the verbal reprimand been disclosed, certainly the defendant could have impeached Captain Amburn's credibility. But the details of this particular piece of evidence mean that its alleged suppression does not undermine confidence in the verdict. So the reprimand here, as you pointed out, Judge East, has nothing to do with this defendant's case. It's not related to any of the facts here. It's not related to Chief Henderson. It occurred 3 years after the offense. It does not relate to a grave misdeed of Captain Amburn's, but rather a failure to report what a fellow employee told him and then subsequently what he overheard. And it's the state's position that the jury would have drawn a distinction between what Captain Amburn did here and in terms of not disclosing something about a rival for a position, that is different than not disclosing or than helping a superior cover up information. So it's the state's position that the jury would have drawn a distinction, and that cross-examining Captain Amburn about the verbal reprimand wouldn't have undermined his credibility in such a way as to make the jury reconsider its verdict, especially once we take the explanation into consideration. And further, the state's case here did not turn solely on Captain Amburn's testimony and credibility. We have Mr. Sumner testify that he saw the defendant drink whiskey on the evening of the collision. We have Chief Henderson say that he saw the Kia drive recklessly. But we also have David Hickey, who's an uninvolved bystander, say that he saw the Kia fly past his residence, and then he saw the defendant stuck in the driver's seat in the immediate aftermath of the collision.
So there was some question at trial about who was actually driving the car.
Oh, yes, that was a very hotly contested issue. So not only as to the defendant's position in the driver's seat, we have Chief Henderson, we have Captain Amburn, but we also have David Hickey, who says, I saw the defendant in the driver's seat. We also have the defendant's injuries, and we have limited information about the car, but we do have photographs of the car. And it's the state's position that the defendant's injuries are consistent with being in the driver's seat, that there's not another explanation for it.
Let me interrupt. Did it also read in your brief that he admitted to hospital personnel when he first arrived at the hospital that he was drinking and driving?
I believe that is in there. There's
Then he, in his statement to the officer, said that he wanted to apologize to the people he was running from?
He did, and then he also told Mr. Sumner that he ran from the cops and that, quote, he gave them hell, and that, quote, he really screwed up. So we have, so Captain Amburn's testimony was important, but it's not, this case did not turn on Captain Amburn's testimony. And to move into the error coram nobis, it also didn't turn on Chief Henderson's testimony. I think the most important part of the error coram nobis claim is that neither the evidence of the justice incident nor the indictment brought by the federal authorities constitutes newly discovered evidence that may have resulted in a different judgment had it been presented at trial. I mean, it is impeachment evidence, but there's no reasonable basis to conclude that the evidence may have led to a different trial result under the circumstances of this case. The defendant's claim is that had the jury heard this evidence, it would have believed his argument that Mr. Henderson caused the collision by initiating the dangerous chase in his Tahoe and then covering it up. But it's unlikely the jury would have accepted this argument even if it had heard about the justice incident or about the indictment. Given Captain Amburn's testimony that he was in the lead, the recorded dispatch call which captures Chief Henderson stating that he's behind Chief Amburn, Captain Amburn's testimony that his lights and sirens were on, that recorded call to dispatch where you can actually hear the sirens, and then Officer Lane, who's not part of the narcotics unit, testifying that policy dictated that there wouldn't be a crash reconstruction because there was no fatality. And so at the time, the victim did die, but she died after surgery at the hospital. So given the timing, Officer Lane's testimony was that because nobody had died at that point, there was no reconstruction. So certainly the jury could have disregarded all of Chief Henderson's testimony, could have found that not a bit of it was credible. But it's still unlikely the jury would have reached a different result. So Chief Henderson's testimony here was important because he helped establish that the Kia was driving recklessly, and that in the immediate aftermath of the collision, the defendant was in the driver's seat, that he was fighting with the airbags in the driver's seat, and that he smelled of alcohol. But again, at the risk of repeating myself, Captain Amburn also testified the Kia was driving recklessly. That's supported by the dispatch call because he's narrating what's happening. And Captain Amburn also put the defendant in the driver's seat. David Hickey, again, the uninvolved bystander, said that the Kia drove past his house really fast. He put the defendant in the driver's seat. Captain Amburn said that he also saw the defendant fighting in the airbags, but frankly, whether the defendant's fighting with the airbags or not really doesn't matter. And as to the testimony Chief Henderson offered about smelling alcohol in the defendant's person, the value of that surpassed by the hospital record saying is a 135 and the TBI saying 180. So for the jury to reach a different result in this case, it would have had to find reasonable doubt that the defendant was driving, that the defendant was intoxicated, or that the defendant caused the collision. But to reach any of those, find reasonable doubt on any of those points, the jury would have had to basically set aside a large amount of evidence. To find reasonable doubt that the defendant was driving, they'd have to find Chief Henderson wasn't credible, Captain Amburn wasn't credible, Mr. Hickey wasn't credible, that Miss Howell was in the driver's seat, because it could only have been the two of them, but she somehow got out of the driver's seat without any damage to the leg, despite the photograph showing that most of the impact was in the center column, focused on the driver's seat. So you'd have to find that Miss Howell got out of the driver's seat without any damage, that she walked around her car to the passenger side, despite her severe injuries that were so severe she couldn't even talk when Captain Amburn saw her, that she spun around, landed on the ground, and that she did all of this before Captain Amburn and Chief Henderson arrived on the scene. They'd have to find that the defendant's injuries were not the result of being in the driver's seat, but that he shattered his pelvis, destroyed his knee and his leg, his right knee and his right leg, by climbing from the passenger seat into the driver's seat. And then he'd have to find that the defendant lied when he told Captain Amburn that he was driving, and I believe other first responders, and that he lied when he told Mr. Sumner that he fled from the police and that he was driving the car. Because he never made any suggestion to Mr. Sumner, despite their conversations about this many times, that anybody other than him was the driver. To find reasonable doubt of intoxication, the jury would have to disregard Mr. Sumner's testimony, have to disregard all of the BAC information, and the defendant's own testimony about his intake of alcohol. To find reasonable doubt that he caused the collision, would have to disregard the intoxication and the reckless driving that's established by the witnesses, and find that something else caused the collision. But there really isn't anything else. Because reaching this conclusion, the jury would have to disregard the defendant's own statements that he fled from the police, that he was really sorry, that he messed up, that he gave the officers hell. So there's just, in another case, Chief Henderson's testimony would, the indictment, the information about the justice incident would be very bad. But under the circumstances of this particular case, there's just so much other evidence of the defendant's guilt that it is unlikely that the trial result may have been different had the jury heard about this information. So if there are no further questions, the state asks this court to affirm the judgment of the trial court.
Thank you, ma'am. Madam Clerk, let's give him 4 minutes, please.
I have 2 brief points on the blood. The issue is not just whether this sample was degraded in some way. The issue is also, how do we even know this blood belonged to Harlan Ferguson?
Well, in this case, it was medical blood, right? So you cited the Cannon case with the pantyhose, and the pantyhose perhaps were cut off of the victim in that case to administer treatment, but here you've got medical blood taken by hospital personnel, presumably for their purposes until police served the warrant, right?
We have, the hospital took some blood.
Right, for whatever testing they were
whatever
going to
reason.
do. They didn't take it at law enforcement's direction. It was only provided
I agree.
from the warrant. So how can we even count, how can we even analyze what was done before the police obtained custody of it? How can we control the hospital, what they do, what hospitals do every day?
Well, we can't control it, but we can put a witness on about it. Right? That's the problem, is you call a witness to say, this is what happens in the hospital. This is how we keep blood samples in the lab separate from other people's blood samples. This is the kind of phlebotomist who draws the blood. Maybe here's the phlebotomist who did. But we just have, all we know is they show up with a search warrant. Some guy goes into the back and comes out and says, here you go, right?
That is true. You said it was litigated pre-trial, so at that point, the defense wasn't ambushed at trial by this issue. The defense could have put on some proof to the contrary to show there actually were errors in the hospital's procedure, correct?
Yes.
Okay.
It is our position that it's not our job to defeat the chain of custody. It's their job to establish it. The opposing counsel cited the Singh case. I will just point the court to the Singh case. And the first criteria in the Singh case list is investigating officer testifies he or she watched the blood draw and received the sample from a nurse or phlebotomist. We don't have that or the equivalent here. I want to talk.
Let me ask you this, though. Are you alleging that the .13 that was in the hospital records, are you saying that wasn't the defendant's blood? Are there some question about whether that was the defendant's blood? Or
We don't
only-
know anything about I don't know anything about it other than it's written on a sheet of paper that should not have come into evidence, 135.
But it did come into evidence
Yes,
without objection.
with objection. I mean, that's all the medical records
with
should
objection or without objection?
with objection.
What
Was that
the
part of the
objection?
1,500 pages?
Yes.
Okay.
I'm sorry, I missed that. What was the nature of the objection?
That all of the records were introduced wrongly under this rule of completeness
But
idea. If I can briefly turn to the quorum nobis issue, I think the difference we have is one of maybe of jury psychology. It is our position, it is my fervent belief that had this information about Mr. Amburn and particularly about Mr. Henderson come in at trial, the jury would not have done what opposing counsel ably did, which is to say, okay, that stuff is really bad, but can we pick and choose from the rest of the case and still come up with enough to establish reasonable doubt? I believe
I
that...
mean, what's the reasonable doubt? The reasonable doubt, I mean, you've said that the jury would have found that the police caused this accident. Maybe that's what you're talking about. Maybe you're saying reasonable doubt whether he was the driver or reasonable doubt he was intoxicated, but I'm not, or are you just saying
All three.
All
Yes.
three.
Yes, a little bit here, a little bit there. Probably the strongest reasonable doubt is about the driver, but there's reasonable doubt about the others as well. I think fundamentally, if this comes out at trial, a jury of 12 East Tennesseans is going to say, we're not buying what Mr. Henderson is selling, right? This is not, we've called out a witness in a minor misstatement. It is.
But isn't that what we used to refer to as a captious doubt? A doubt based upon they don't like the officer. Proof is overwhelming, but they don't like the officer, and that's what I used to think we called a captious doubt. It's really not a reasonable doubt.
I think there is reasonable doubt in this case, and to begin with, but I think the effect of this would have absolutely destroyed the credibility of the state's entire presentation. These two witnesses, so witness number 2, witness number 3, hundreds of pages of testimony of what was being presented by the state to the jury as these are the facts of the case. Oh, by the way, this guy is a criminal. He is a crook. This guy won't speak up when other people do things that are wrong. Yes, could the jury have gone in the back and still sort of parsed things differently? Maybe. But this would have been a detonation in the state's case. Under the Nunley standard, it has a very high standard for veracity of information for quorum nobis, but the information here is stipulated to. We know it's true. It has a low standard for prejudice, may have resulted in a different outcome, and I think understanding how juries actually think, this would have destroyed the state's case.
Thank you, Mr. Harwell. Any other questions? Any questions? Thank you, sir. Thank you, Ms. Redding. Thank you both for well-written briefs and good arguments. Madam Clerk, if you would please call the next case.